Good morning, Mr. Judge Dorsey. We are on the record in Mallinckrodt PLC, case number, the adversary proceeding 21-50242. This is the time the court set for the hearing on the temporary restraining order requested by the debtors and this adversary. Go ahead and turn it over to debtors' counsel.
Good afternoon, Your Honor. May it please the court, Bob Stern from Richards, Layton and Finger on behalf of the debtors. Can Your Honor hear me okay?
I can, thank you.
Good. As Your Honor noted, there's a single item on today's agenda. It's debtor Mallinckrodt PLC's motion for temporary restraining order. Hugh Murtaugh of Latham & Watkins is going to present the motion today on behalf of the debtors, and with the court's permission, I'll turn the virtual podium over to Mr. Murtaugh.
Okay, thank you. Mr. Murtaugh?
Good afternoon, Your Honor. Can you hear me okay?
I can, thank you.
Okay. Thank you, Your Honor. For the record, it's Hugh Murtaugh from Latham & Watkins on behalf of debtor Mallinckrodt PLC. Your Honor, for order of operations, I would dispense with any opening and would propose just to put the evidence in the record and then proceed to argument.
All right.
So to begin, Your Honor, we start with the declaration of M. Viola So. That's docket number 5 in the adversary proceeding. The substance of Ms. So's declaration is simply to compile and submit the various public statements made by defendants in the proceeding. Ms. So is available at the hearing for cross-examination. We would move her declaration and the exhibits into the record now.
Any objection? They're admitted without objection.
Second, Your Honor, the declaration of Randall Eisenberg of Alex Partners. Mr. Eisenberg is also live on the hearing and available for cross-examination. We'd move his declaration in as his direct testimony in support of today's motion.
Any objection? Admitted without objection.
And finally, Your Honor, the declaration of Dr. Stephen Ranello of Arthur Cox. I believe that's item number 6 in the adversary proceeding. Dr. Ranello is also live in the hearing today and available for cross-examination, and we submit his declaration as his direct testimony in support of the motion today.
Any objection? Admitted without objection.
Thank you, Your Honor.
Anyone wish to cross-examine any of those 3 witnesses? All right. Go ahead, Mr. Murtaugh.
So for the argument, Your Honor, I'll just give a brief introduction, then go through the factual history that brings us here today and finish with the reasons that a TRO should issue. So briefly, by way of introduction, debtor Mallinckrodt PLC is here requesting entry of a temporary restraining order to halt the ongoing harm caused by Mr. Parker's and the Buxton Helmsley Group's illegal and abusive campaign to convene an extraordinary general meeting of PLC shareholders. The avowed purpose of that meeting is to displace all of the existing directors and certain senior management and to replace them with Mr. Parker and others chosen by him for the purpose of seeking an equity recovery, notwithstanding this court's holding that the debtors are hopelessly insolvent. In the event, which is to say this certainty that there will be no equity recovery, the defendants here have threatened on multiple occasions instead to seek a liquidation of the debtors. The defendants here have solicited support for this meeting in open violation of U.S. securities laws intended to ensure that such solicitations are conducted on the basis of full and fairly informed basis. And I'll give just a word on the securities laws because I think it will help contextualize the factual background that I will give in a moment. Your Honor, Section 14A of the Exchange Act and the related SEC proxy rules seek to ensure that when shareholders grant proxies, that is, when they authorize someone else to exercise the voting power of their shares, that the proxies be granted on a properly informed basis. The proxy rules contain 2 main pillars to achieve the objective of proper information. First, the rules prohibit the solicitation of proxies by means of communications that are materially misleading. That's Rule 14A9. Second, the rules also require that proxies may not be solicited unless the person soliciting them has first filed a proxy statement with the SEC, which must then be furnished to each person whose proxy is solicited, and that's Rule 14A3. As the factual history will demonstrate here, Your Honor, defendants have disregarded those laws, resulting in highly misleading, inflammatory, and often outright false communications. Beyond the securities violations, defendants' conduct, that is pursuing a shareholder action for no viable purpose other than the destruction of this reorganization, is a clear abuse of shareholder rights, and it is separately subject to injunction under bankruptcy case law. In short, defendants' behavior is causing and threatens to cause more and increasing irreparable harm to the debtors, their stakeholders, and this reorganization, and it should be stopped. So, who are the defendants? What have they done? And what are they threatening to do? Mr. Parker is here pro se. Based on public corporate filings, he is the president, secretary, treasurer, sole director, and sole employee of defendant Buxton Helmsley Group, which advertises itself as an asset management and financial services firm. Defendants first came to our and this court's attention when they filed a letter styled as a motion for appointment of an equity committee. When this court pointed out to Buxton Helmsley Group that it could not proceed in this court pro se, an ad hoc group of equity holders picked up the mantle of the equity committee motion. This court held a full evidentiary hearing on that motion, and at the conclusion of that hearing, this court held that the debtors are hopelessly insolvent and that equity has no economic stake in these cases. Defendants clearly were not satisfied with that ruling, and they launched the instant campaign. So on January 15th, 2021, they issued a press release, launched their website, revivemallinckrodt.com, and issued a letter to shareholders to begin a public proxy campaign to call a shareholder meeting to replace the current board with Mr. Parker and those chosen by him, and thereafter to upend the bankruptcy proceedings. Defendants' whole proxy campaign was built on a series of false and misleading assertions. First, Mr. Parker told shareholders that Mallinckrodt was actually solvent, that there was plenty of value here for equity. He called the claim that Mallinckrodt is hopelessly insolvent, quote, groundless, when this court had found just the opposite. He touted a valuation of $11 to $30 per share without mentioning that this court rejected that very valuation. And he claimed, among other things, that there are, quote, many, many routes of preserving shareholder value. Plainly, all of these statements were without any basis and were contradictory to the ruling that this court had recently made. Second, he accused management and the board, without any support or evidence, of selling out equity just to line their pockets. He claimed that the company was, quote, going to enrich management with a 10% allocation of the reorganized company, when, as this court knows, any post-reorganization equity incentive grants will be made to post-reorganization management by a post-reorganization board elected by new post-reorganization shareholders. He further accused the board and management of, quote, having breached their fiduciary duty to shareholders, of acting in bad faith, and of acting merely to preserve their paychecks, smearing the board and management without any basis. Third, he threatened multiple times to seek liquidation if there were no deal for equity in these Chapter 11 cases, stating, for example, quote, BHG believes that if equity cannot seal an advantageous deal...
Mr. Murtaugh, was that you making that noise or was somebody else?
No, Your Honor.
All right, yeah, if you're not speaking, please mute your phone. Go ahead, Mr. Murtaugh, sir.
No, thank you, Your Honor. Third, he threatened multiple times to seek liquidation if there were no deal for equity in these Chapter 11 cases. He stated, for example, quote, BHG believes that if equity cannot seal an advantageous deal, creditors should scavenge for value just as much as equity holders, leaving a Chapter 11 liquidation the only way to prove out true actual value of assets and subsequent true shareholders' equity. There are many other statements to the same effect. And of course, there was no support to say that a Chapter 7 liquidation would return more value to equity than a Chapter 11 reorganization. In either case, there is no value for equity. Now, the requisition forms and the document entitled proxy for votes at the EGM that were supplied as part of this initial January 15th solicitation were both proxies under U.S. securities law. Both were forms allowing BHG to legally exercise the power of the holder's shares. However, defendants filed no proxy statement for either, and they filed none of their materials with the SEC. Defendants then went on to issue multiple press releases and further communications, including a January 20 press release reaffirming their previous assertions and calling management and directors, quote, traitorous, a January 26 email urging investors to acquire additional shares to, quote, enhance their personal profit potential, again relying on the discredited $11 to $30 per share valuation, and again without referencing that this court had discredited that valuation or that the court had concluded that the debtors are hopelessly insolvent. Next was a January 27th press release announcing, quote, sufficient shareholder backing to call an extraordinary general meeting, and now accusing management and the board of, quote, committing one of the largest breaches of fiduciary duty in the history of business, and threatening to reveal documents that would, quote, destroy the reputations of Mallinckrodt's fiduciaries. These further communications were, of course, unsubstantiated because they're false, and none was filed with the SEC. In February, defendants provided two updates to shareholders, one on February 8th explaining or alleging that their website was down due to hacking attacks, but urging readers to hold because they will, quote, be happy they did. And another February 18th update urging holders not to sell and reaffirming defendants', quote, dedication to their initiative and implying falsely that the SEC was on their side because it was, quote, following the situation very closely. Needless to say, these February communications also were not filed with the SEC. Now, despite having taken down their website, which remains down, defendants appeared to have continued to solicit support. On March 5th, 2021, defendants filed a Schedule 13D that announced a shareholder group holding about 5.4% of outstanding equity, while suggesting that there was further support, but it was too administratively burdensome to include it all in the filing. On March 6th, defendants sent a letter to shareholders promising that the defendants would shortly file a demand letter with the company and promising that if the company did not respond, then the defendants would immediately call the shareholder meeting. Finally, on March 10th, defendants did send a letter to Mallinckrodt's board of directors demanding a response and that if none were forthcoming by March 12th, which was Friday, they would face immediate action. And as a result, on March 12th, Mallinckrodt PLC filed the instant complaint and the TRO motion. Your Honor, defendants' conduct is illegal and destructive and should be restrained until a preliminary injunction hearing can take place. As Your Honor knows, courts in this district generally consult the preliminary injunction factors when deciding whether a TRO is appropriate, and those factors are likelihood of success on the merits, irreparable harm to the movement, balancing of the equities, and an examination of the public interest. And in this case, all of those factors weigh heavily in favor of granting a TRO. So starting with likelihood of success, a PLC is highly likely to succeed on three separate claims, two under U.S. securities laws and one under Section 105 under bankruptcy jurisprudence. So beginning with the securities laws, defendants have violated those laws in two separate ways, both by failing to adhere to any of the basic proxy rules designed to ensure dissemination of full and accurate information, and then also by filing misleading and false information. So starting with the bedrock proxy rules, Rule 14A3A provides, quote, no solicitation shall be made unless such person solicited is concurrently furnished or has been previously furnished a publicly filed preliminary or definitive proxy statement containing the information specified in Schedule 14A. The required proxy statement is the primary vehicle through which the securities laws and the SEC ensure that decisions by the corporate electorate are made on a fully and fairly informed basis. As a result, the proxy rules specify in great detail the form, the content, the manner, and the availability of the proxy statement. As noted, defendants here have solicited requisition forms as well as expressly a proxy form for the agenda for the hoped-for extraordinary meeting. Both are governed by Rule 14A3A, but defendants have never filed or furnished a proxy statement for either. Notably, while there is an exception to Rule 14A3 for dissemination of certain antecedent materials prior to delivering proxies, even that rule cannot be satisfied here because that rule would require that all of the antecedent materials are submitted to the SEC. And as we know, defendants have never submitted any of these materials to the SEC. So in short, defendants did nothing to comply with bedrock securities laws to ensure full and accurate information. That's the 14A3 violation. Instead, defendants' steady stream of solicitation materials further violates securities laws by making multiple materially misleading statements and omissions. And here, Rule 14A9A prohibits solicitations, quote, containing any statement which is false or misleading with respect to any material fact, or which omits to state any material fact necessary in order to make the statements therein not false or misleading, end quote. Having ignored all the procedural safeguards, defendants have disseminated numerous materially misleading statements and omissions, including, but not limited to, the following. First, as to value, that PLC equity has quote unquote profit potential and a fair valuation of $11 to $30 per share, without any disclosure that this court had discredited that valuation, determined equity had no value, and declared the debtors hopelessly insolvent. Similarly, that a liquidation of the insolvent debtors could somehow result in value for equity. Second, numerous character attacks, baseless misleading character attacks, are prohibited under Rule 14A9. Those include assertions that management and directors are traitorous, are merely protecting their paychecks, are committing one of the biggest breaches of fiduciary duty in the history of business, are destroying retirement accounts with no qualms about it, are enriching themselves with post-reorganization equity. All such baseless character attacks are misleading and prohibited. Third, that the status of the reorganization is uncertain, that virtually no quote, this is a quote, virtually no parties support the RSA, unquote, except, quote, those receiving highly preferential treatment, unquote. Despite the RSAs, in fact, being supported by many key stakeholders, and the fact that most of those stakeholders are accepting or planning to accept deeply impaired recoveries. Fourth, statements as to the level of shareholder support. Defendants have implied and alleged consistently that they have sufficient shareholder support to requisition an extraordinary general meeting, and yet they filed a 13D statement cataloging about 5% support, which is roughly half of the support necessary to convene an extraordinary general meeting. So this catalog of ongoing and inflammatory misstatements is a separate securities law violation under Rule 14A9. Defendants have no defense to these violations, and thus PLC is likely to succeed on the merits of the securities claims. Now, Your Honor, in addition to the securities claims, PLC has a claim under 105, Section 105 of the Bankruptcy Code, for an injunction for clear abuse of shareholder rights. Precedent is clear, Your Honor, that a bankruptcy court may enjoin the occurrence of a shareholder meeting, as well as the implementation of the results of such a meeting when there is clear abuse. In other words, a showing of delay and real jeopardy to a debtor's reorganization. And that's a quote from SS Body Armor from the Bankruptcy Court in Delaware, 527 BR 597. Now, while of course courts will and should protect the rights of shareholders to exercise bargaining power in good faith, that consideration falls away where, quote, the shareholder's action demonstrates a willingness to risk rehabilitation altogether in order to win a larger stake for equity. And that's the Marvell case, 209 BR at 838, quoting John Mansville, which is 801 F 2nd at 65. More importantly, here, shareholder bargaining power becomes irrelevant where the debtor is insolvent. As the Mansville court held, if the debtor were determined to be insolvent so that the shareholders lacked equity in the corporation, Denial of the right to call a meeting would likely be proper because the shareholders would no longer be real parties in interest. Here, this court has already determined that the debtors are hopelessly insolvent. There can be no advantageous deal for equity because the shareholders have no economic interest in these cases. Indeed, as Dr. Ranelow's testimony makes clear, no board, not this board, not any board helmed by Mr. Parker, nor any board chosen by any other person, can discharge its fiduciary duties under Irish law by pursuing an equity recovery that just doesn't exist. And the same is, of course, true under US law. As a result, defendants' proposed course of action is at best entirely pointless. But defendants' plan is, of course, worse than pointless. It is avowedly destructive. Defendants have promised to liquidate the debtors if they cannot achieve an advantageous deal for equity. But we already know there can be no such deal, and therefore defendants are in fact committed to destroying the reorganization by liquidating the company. While PLC, as much as anyone, recognizes the importance of shareholder rights, this is as plain a case of clear abuse as we are likely to see. And as a result, PLC is also likely to succeed on its claim under 105. Turning to irreparable harm, Your Honor, PLC is being irreparably harmed and is under threat of even more severe harm until defendants are restrained. First, the company, simply as an issuer of securities, is being irreparably harmed by defendants' continuing solicitation of shareholders by means of false and misleading information. The very purpose of the securities laws is to protect shareholders' rights to receive full and accurate information. And courts have been clear that deprivation of such a right is an irreparable harm that the issuer itself has power to enjoin. And for that, I'm relying on Dyson Electronics, that's 772 F sub 859 from the District of Delaware. The unabated dissemination of inaccurate and false information creates an expanding body of misled investors, as Defendants 13D filings make clear. And if defendants are not enjoined, they'll continue to make more and more outrageous statements to continue misleading investors. Second, Your Honor, separate and apart from the irreparable harm that arises just from the securities violations, defendants' actions are damaging and risk even more damage to the debtor's reorganization in numerous ways. Mr. Eisenberg's testimony substantiates the following at least. Defendants' inflammatory statements and falsehoods, including personal attacks on management and directors, distract management and directors from their focus on the reorganization. The misleading statements to equity are calculated to cause increased and new investment. Not only will those investors be harmed when PLC equity is canceled, the debtors are harmed by the creation of an expanding body of equity holders who are incentivized to disrupt this reorganization on the false promise of an equity recovery. Next, these misleading statements can move through the capital structure. If equity believes there is a recovery, then creditors may be inclined to believe they will recover in full, which is also misleading and likely to disrupt these cases. Ultimately, these doubts could extend to the RSA parties themselves, causing them to disengage based on perceived uncertainty about who will lead the company and its direction. Next, Your Honor, as Mr. Eisenberg also testifies in his declaration, all of these harms will become significantly more severe if the debtors are permitted to escalate their campaign by purporting to submit a requisition for an EGM. In that case, company management would be forced to devote even more time to responding to the meeting request, potentially noticing a meeting, and preparing for such a meeting. More investors would likely become interested in the false story of equity recovery, making more losing investments and creating more disruption in these cases. Stakeholders would begin to have real doubts about the company's ability to hold together the RSA and confirm the proposed plan. And the cases could frankly lose much of the momentum that the debtors, their professionals, and their management have worked so hard to create. Finally, as Mr. Eisenberg also testifies in his declaration, if defendants were able not only to validly requisition an EGM, but also to carry through their threatened agenda, the effects are potentially disastrous. As we've said several times, defendants' stated goal is to abandon the RSA, displace the directors and senior management, and replace them with directors and management who will seek equity recovery or liquidate the company. Since there is no equity recovery, presumably the result will be liquidation, and liquidation will result in a massive loss of value to all of the stakeholders in these cases who have a real economic interest to protect. So in summary, Your Honor, on irreparable harm, some irreparable harm has already occurred, but we have an opportunity now to prevent escalating irreparable harm from occurring in the very near future by the escalation of the defendant's actions through the threatened requisitioning of an EGM. Turning to balancing of equities, Your Honor, quickly, on the other side of the scale, the defendants do not suffer harm if they are required to pause their campaign until this court has had an opportunity to determine whether a preliminary injunction should issue. Even if the court were to determine that no preliminary injunction should issue, defendants would face simply a delay of 14 days. And finally, on the public interest, Your Honor, public interest favors entry of a TRO for at least 3 reasons. First, entry of the TRO will prevent further possible violation of U.S. securities laws. Second, entry of the TRO will prevent defendants from making statements that are calculated to mislead investors into investing in PLC equity. And third, entry of the TRO will protect the debtor's reorganization, and the public interest favors successful reorganization. So, Your Honor, for all of these reasons, the court should enter the TRO and halt the irreparable harm that is being visited upon PLC.
Thank you, Mr. McClung. Mr. Parker, do you have counsel?
I do not have counsel. I was not able to find them in the 3 days or so allotted, but I understand why you felt obligated to schedule this here today. But I figured that would likely be the outcome, unfortunately. That said, I have prepared what I believe is a very durable defense testimony. It will probably take 30 minutes or so. I'll get through it as quickly as possible. Hopefully we'll make this ruling quite easy for you. And while I am then ready to proceed today, I hope that you will understand, however, that I am not comfortable taking any questions from opposing counsel as part of any cross-examination, given I do not have counsel present. I would like to say now that if any questions are given, I must exercise my Fifth Right Amendment and avail myself. I say this in advance to help all understand that is a decision that is without prejudice to any question given. I'm just in a bit of a rock and a hard place here with the timing, but I, again, understand your obligation to hear this today and would like to make it work.
Well, if you testify, Mr. Parker, parties are going to have an opportunity. The debtor's going to have an opportunity to cross-examine you. If you want to invoke your Fifth Amendment right against self-incrimination in response to those questions, you can do so, but they're going to have a right to cross-examine you.
No, I know. I'm sure they're going to attempt it, but I don't feel comfortable asking questions, no matter the question. It's not with prejudice to anything. I believe that my testimony itself is sufficient enough for you to understand the situation and why they're alleging what they are, and why I have also done what I have done.
Well, do you want to do this as well? Okay, we're going to have to. You don't have anybody asking you questions, right? You just want to speak in a narrative format?
Yeah, I just want to speak in a narrative format. I believe this is going to more than cover, like I said, it's probably going to take 30 minutes or so, but I think it's quite durable. I don't think I've done extensive research on all of these issues.
Your Honor,
Go ahead.
I'm sorry, Your Honor. I'm just a little unclear what Mr. Parker is proposing. I don't know if Mr. Parker is proposing to make an argument or if he's proposing to actually examine himself, whether he's purporting to represent himself or to speak for Buxton Helmsley Group. There hasn't been any submission of a witness or exhibit list. We have no notice of his intent to testify. I would object to any attempt for him to put himself on the stand and examine himself, and also to preclude cross-examination.
I'm not looking to examine. Yeah, go ahead. Sorry.
Go ahead, Mr. Parker.
No, I was just going to say I'm not looking to examine myself. I'm looking to give a defense, but I'm not willing to answer questions from opposing counsel merely because, and I'm not looking to cross-examine any of them. I don't believe that's necessary. So.
Well, as I said, Mr. Parker, if you want to testify as to factual information, they have a right to cross-examine you about that factual information. If you want to just give an argument, that's a different story, and I can allow you to make your argument
I would say it's more that.
Without being put under oath, because if you're going to testify on facts, I'm going to have to put you under oath. You're going to have to testify, and then I'm going to have to let the other side cross-examine you.
I don't believe what's within here is, I mean, some of it, I guess, could be deemed factual in terms of, I mean, there are numbers involved and so forth. And I understand they will likely attempt to ask questions. But I would say it's more of an argument. I don't think, I'm not referencing cases or anything.
Well, that's fine. All right, here's what we're going to do. I'm going to allow you to speak in as if this was argument, as opposed to testimony. To the extent you are going to argue facts that you have not put into evidence, I'm going to ignore those because they're not in evidence, because you're not testifying. Is that clear?
Okay, that's okay.
All right.
Okay.
Go ahead, then.
Your Honor, if it pleases the court, just before Mr. Parker begins, given the nature of this proceeding and that Mr. Parker's pro se, I'll attempt to refrain from interrupting the argument. But based on what Your Honor just said, I just would like to lodge an objection to the extent necessary that any facts relied upon are not in the record and are not evidence in these proceedings.
That's going to be the case because he's not under oath, he's not testifying, he hasn't presented any other evidence. So whatever he says as a factual matter, I'm going to disregard. But if you want to make an argument, Mr. Parker, as to why I shouldn't enter a TRO, you can do so.
Okay. I mean, I understand that. Can I proceed?
Go ahead.
Okay. So let me start by saying that this adversary complaint should be dismissed for endless reasons, largely because the prayers for relief of the plaintiff were not even brought forth to the correct court. The plaintiffs are attempting to strip their shareholders of an Ireland incorporated company of their rights to call a shareholder meeting in a U.S. court, whom they have great reason to fear an imminent uprising from due to their numerous violations of fiduciary duties and corporate governance rules. I personally do not believe such an army of lawyers could not easily conclude themselves that the United States could not strip the rights of shareholders internationally of those rights afforded to those shareholders by the Irish government and its legislation as part of this company's Irish incorporation. If this court of Delaware was not in the picture, they would have never thought this court was suitable to request such relief and would have known an Irish court is the only court with jurisdiction over Irish shareholder rights. It would also be as if a Delaware corporation was attempting to strip rights of its shareholders in a Florida court, yet in this case, we're not even talking the same country, making it even more logical. The only reason they brought this malicious case before this court is a desperate attempt to muzzle and oppress the shareholder base any more than they already have. These directors in this management abandon their shareholder base and clearly certain creditors, which they claim they have a duty to, far before filing their Chapter 11 petition. They are threatened because the shareholder base realizes the numerous basic routes which these directors in this management had an obligation to minimally explore to preserve and maximize stakeholder values, yet they didn't. And because we have organized to exercise our legal rights afforded by the Irish Companies Act of 2014 to overturn them. It is not surprising those numerous very basic routes to preserving maximum stakeholder value were not explored, with 11 out of 12 directors in violation of their ongoing equity retention requirements as of the date the plaintiff filed their Chapter 11 petition in this court, along with every single executive officer being in violation of their agreed to ongoing equity retention requirements too. It is utmost clear why this leadership engaged this restructuring attempt in this court when they had no vested interest in this company. They know that if we brought this to an Irish court, it is with almost certainty that they will be assuming personal liability from their many acts of negligence and gross acts of breach of fiduciary duty to both shareholders and creditors. And given their willful continuance of their breaches of duty, it is an almost surety that this company's director and officer insurance policy will no longer cover our leadership, just like WorldCom and Enron, leaving them personally liable in that regard too. And the only thing that keeps directors and management of companies in line with shareholder interests are the very democratic procedures and rights to call shareholder meetings, which they are attempting to restrict and strip from us. It could not be more apparent their motives, and I do not blame them for it. They would have a lot to be worried about with the shareholder base contemplating or calling a meeting, and a lot to worry about if we are forced to bring this before the High Court of Ireland. I think while I have framed my pronouncements of their deplorable and self-serving behavior very bluntly, they should have very much realized that my firm request to speak with the board last week was an olive branch to right their wrongs without forcible intervention, and they torched that olive branch here with this lawsuit. It does not exist anymore after this retaliation. They do not get to complain about being called corrupt when they have broken our corporate governance rules and not only betrayed us, but multiple other stakeholders, then attempt to self-deal value to themselves while they leave us with an empty bag and tell us to deal with it. They claim that it is wrong when I said that they have no qualms about what has happened here to multiple stakeholders. But they do not get to rebut that when they voluntarily hand us an empty bag and again tell us to deal with it after not attempting numerous of the very basic routes to preserving and maximizing the value of this company all the way up through the capital structure. They know that the Irish government would have a heyday if they knew that these directors and officers effectively pillaged the pot before declaring it short to shareholders and creditors, both with their retention bonuses and taking above average cash compensation in lieu of equity grants just prior to their declaration of insolvency. That could not be in more stark violation of Irish law. When you're insolvent or question your insolvency, you have a duty to your stakeholders not to begin self-dealing extra money because you have the feeling you're in a pickle and feel the well may be drying up. They had an opportunity to repair their relationship with their shareholder base and incentivize us to possibly not call a meeting with my request to speak with the board, but they blew it and further retaliated with this lawsuit. I could have simply called a meeting. The plaintiff says my written statements are riddled with falsehoods when their complaint is chock full of them. Most materially, when they state an extraordinary general meeting under the Companies Act of 2014 could only be brought forth with a 10% representation of shareholders requisitioning such a meeting. I surmise they know that is not true too, or else they would have not felt so threatened as to have to file this adversary complaint here. They would have not felt threatened if they knew I could not call a meeting of the shareholders at any moment. Section 178 of the Companies Act of 2014 very clearly states, the directors of a company shall on the requisition of one or more members holding or together holding at the date of the deposit of the requisition, not less than 10% of the paid up share capital of the company, as at the date the deposit carries the right of voting at general meetings of the company, forthwith proceed duly to convene an extraordinary general meeting of the company. But they are indeed threatened, as Section 1101 very clearly states that in the case of a traded PLC, which I will get to that definition in a moment, Section 1101 shall apply as if its subsection should replace the standard subsection, standard 178, Section 178, subsection 3 statute that I just read to you, which is that the directors of a company shall on the requisition of one or more members holding or together holding at the date of the deposit of the requisition, not less than 5% of the paid up share capital of the company, as at the date of the deposit carries the right of voting at general meetings of the company, forthwith proceed duly to convene an extraordinary general meeting of the company. Further, Section 1099 states that a traded PLC means a PLC whose shares are admitted to trading on a regulated market in any member state of the European Union. This company's shares are currently listed on Germany's Frankfurt Stock Exchange under ticker MCD. Germany has been a member state of the European Union since its founding in 1993. So while the plaintiff would like to falsely claim I am misleading, they could not be more misleading in their complaint against me. They've effectively declared, I do not know what I'm talking about in this regard, when they knew it was not true. They are lawyers after all, so I would say that is slanderous in itself. I do not want to say they lied in their complaint about this, but I must believe that their army of lawyers are more well-versed in law than I am. I do not consider myself as being intelligent in any above-average way. I'm literally and simply reading the pages of the Companies Act of 2014. And while the plaintiff half-jokingly says Mr. Park would like to instate himself as chairman and CEO, that is because this shareholder base cannot afford any chance of continued harm by our leadership for this travesty to continue, or any chance that this company's leadership will again stray so far from the interests of its stakeholders. I do not possess experience in the pharmaceutical industry, but that is not what we need at this moment. We need someone with the skills required to solve these short-term headwinds, and more importantly, in a way that upholds the chief executive's fiduciary duties to creditors and shareholders. Those skills require extensive knowledge of capital structuring, mainly, along with more strategy and determination than presently being engaged to resolve our current litigation issues in a manner fair to all stakeholders in the capital structure, which I will detail more as I go on here. I very much believe in the adage that it is better to have a lesser intelligent person with ethics than a genius without ethics. A genius without ethics will know every way to use their above-average intelligence in the most unethical ways. This company needs new leadership that has a demonstrated interest in ensuring that we will achieve an ethical resolution here and follow Irish laws regarding fiduciary duties throughout this process. And to my knowledge, I am the only one who has demonstrated that interest to any real extent. Not any of the other investment banks managing trillions in retirement assets who merely dump their shares. I'm acting out of my fiduciary duty to protect Buxton Helmsley's clients, which I take very seriously, just as I would be if I'm forced to take a short-term assignment on the inside of Mallinckrodt. As a last note on this, we need someone who is willing to take largely contingency-based compensation instead of massive salaries and bonuses that give absolutely no incentive to preserve and maximize the value of this estate for all in the capital structure. The plaintiffs also assert in their complaint that my contemplated actions are falsely justified on grounds of corporate governance violations and breach of fiduciary duty. I wish to cover all of those corporate governance violations and breaches of fiduciary duty so all can understand very clearly. First, they are pursuing reorganization plans that are the route of least assurance of shareholders and multiple groups of creditors, realizing any value, literally no chance for them to realize any value, voluntarily capping their chances at zero from the start. And while this management and board has a mere hypothesis that the company is insolvent, that is again a hypothesis and can only be based on the current unethical restructuring plan on the table. Such insolvency cannot be factually proven unless a liquidation occurred. They did not explore those numerous other resolutions where solvency is very possible, especially when it comes to shifting the strategy for litigation resolution. It is impossible and not provable factually to ascertain the market value of assets either until they are bid on. If they did so, they would realize our equity most definitely would have bidders, and our drugs in the pipeline, which we spent countless millions on for R&D, are not worthless. They are the base for very likely wonderful drugs to help millions of people around the world. They may need some tweaking to get them to the point of effectiveness where they can be used, but they are not worthless. Stratagraft, for instance, is pending final approval with the FDA, but the plaintiffs claimed it is worthless as part of the drug pipeline. But what would this management or board know about the worth of our equity and assets is they conducted no meaningful bidding process for them at all, as admitted in the equity committee hearings as part of the testimony of Guggenheim. I also ask, with this issue, what other assets are they marking to zero, manipulating our accounting and suppressing our balance sheet values? And it is not possible to have any meaningful bidding process on our equity at this time, as buyers would have no clue what the actual balance sheet looks like given the accounting manipulation that has occurred at the express admission of witness at the equity committee hearings, and more terribly, our management. The next breach of duty is self-dealing. The pure fact is that insiders have included a management incentive plan that involves a 10% allocation of a reorganized company going to insiders. Whether it is the current insiders or not, it is still going to insiders, while they are extinguishing equity with no bidding process having been had, and while they claim they have such an astute duty to their creditors, extinguishing certain creditors' claims for little or no consideration at all. That allocation to insiders could have easily just as gone to the creditors and possibly shareholders, but this board and management chose themselves before the very creditors and shareholders which they had and have a duty to put the interest first as part of their fiduciary positions. If this company was liquidated, insiders would receive nothing but the creditors would at least get that value being directed to insiders at present, or might even get paid off completely. We would never know until a liquidation occurred. It is impossible to prove the value of this company until buyers are bidding for assets. It is also impossible to prove the value of equity being turned over as part of the existing RSA as to what it would be worth in the open market post-reorganization under the current RSA. They have no proof of anything here. Again, their theory of insolvency is a mere unproven hypothesis. Merely extinguishing equity does not prove insolvency, especially if you conducted no meaningful bidding process for that equity. If they had conducted a meaningful bidding process of the equity before filing this RSA, they then could have told those bondholders set to receive all post-reorganization equity that they must give consideration in excess of the bid of third parties on existing equity as part of an RSA, or else the only ethical way to uphold this board and management's fiduciary duty would be to sell the equity at that point to the third party without filing a Chapter 11 petition themselves. At that point, a third party could have possibly bought the company and recapitalized it without any restructuring at all. But they didn't do that because they would possibly face organizational structure changes that could possibly alleviate the need for certain management positions. The board would more than likely not be required anymore. The management would receive no pre-restructuring cash bonuses, and the insiders would have no chance of walking away from the restructuring table with a whopping 10% allocation of a reorganized entity, while owning less than 0.03% of the company at present. They again have no proof that shareholders would then not receive a distribution under other strategic alternative resolutions that they have not explored. As far as corporate governance violations, the ongoing equity ownership requirement violations very easily satisfy that category and explain why we are in this situation to begin with. The board and management had no vested interest in the equity of this company. Chief Executive Mark Trudeau owned 228,384 shares worth approximately $157,584 when he was required to own 5.25 million in stock at all times given his salary of 1.05 million, as of the time the plaintiffs filed their Chapter 11 reorganization petition. Then he sold off 95% of the puny equity he did own after filing for Chapter 11 reorganization, as if throwing equity under the bus with these Chapter 11 plans was a reason to further violate our corporate governance rules and dump stock on shareholders who he wishes to leave holding a bigger empty bag. And not one other executive officer was in compliance with their ongoing equity ownership requirements either. Further, 11 out of 12 directors were in violation of their own equity ownership requirements too. These were explicitly stated as requirements and not guidelines in the compensation plan. That means they broke a requirement, which means they violated our corporate governance rules. Then they again pillaged the pot before calling it short to stakeholders when they took their retention bonuses just a month or so before their voluntary Chapter 11 petition filing, and also did in the instance where they advanced above average compensation and hard assets, cash, in lieu of equity grants because they again thought they were possibly insolvent and wanted to take some extra money for themselves before declaring so. Again, these actions would quite certainly bring personal liability on these directors and this management. They violated the stark fiduciary duties they had to their shareholders, to their stakeholders under Irish law. They selectively followed the laws where it suits them very clearly. Further, this management and leadership has settled litigation in no other way than what has been convenient for them. Why would they care if they threw equity under the bus? They didn't own any virtually any anyhow. Let me start by saying that I personally have family members who have been affected by the opioid crisis, but I can tell you that not one of them blames the doctors, pharmacies, or manufacturers who they continue to request those pharmaceuticals from. And if they did seek addiction support, it is still not the fault of those pharmaceutical entities for those family members continuing to consume opioid products. It breaks my heart to see countless people affected by addiction, even more so when I've seen it firsthand in my own family, but ruining the lives and uprooting the financials of countless innocent Mallinckrodt shareholders is not the answer when the choice to initially consume our products with an FDA-approved warning of addiction is not our fault. The state and local governments bringing forth claims of negligence negligence should have had those claims reflected right back. If they did not provide adequate resources for addiction victims, then those state and local governments were negligent in public health policy and resources provided, which is not the responsibility of Mallinckrodt. We provide products, disclose the risks of them, count on consumers to consume responsibly, just like alcohol or tobacco, and then the local and state governments have an obligation to provide adequate public health resources for their communities. If they didn't have the funds, it sounded like they should have managed their tax revenues better. If they had the funds, then they didn't appropriate them properly and did so negligently according to their community's needs. If they did not provide adequate addiction resources, that is their negligence. At that point, we should be bringing forth claims against them equally as large as those brought against us for the harms caused as a result of their negligence. And if they want to claim they provided adequate resources and that those addicted did not take advantage of those resources to the extent necessary of solving their addiction, then that is not the fault of Mallinckrodt. The very hypocritical claims brought against Mallinckrodt should have been reflected right back at those parties, yet they were not. Those parties also claim that Mallinckrodt and its owners are some evil force in society that should be punished through bankruptcy, though they wish to obtain warrants for ownership as part of their settlement in principle and join the party. I do not think a situation could get more hypocritical. We shareholders in this company are not an evil force in society if you wish to join the party. Just like alcohol, it is then our personal responsibility as a consumer by putting it in our body to consume with extreme caution and care. I have personally been prescribed opioids, and I opted to either not take them when prescribed or take much less because I'm exercising extreme caution and care. I'm all for giving aid to those addicted on some level, out of empathy for those who did not have adequate resources provided to them for addiction in their city or state or city. But if they sought those resources and they were not enough, then that is a failure on the part of those cities, counties, states, etc. There are multiple intermediaries, doctors, pharmacies, insurance companies, etc., responsible and obligated for ensuring above average prescription to specific individuals is warranted and not an abuse of the prescription. Thousands of innocent shareholders, perhaps if they saw the faces of these stockholders, they would have some feeling, who are the company Mallinckrodt, should not pay for these frivolous claims or else go to trial to have them quashed. That is the appropriate response, just as largely happened with the tobacco litigation in the 80s. Giving a little shake of the money tree when you realize that you have not adjusted your local taxes to ensure ample funds for community addiction resources is not the answer. That will not provide a long-term solution to resolve the opioid crisis. Collaboratively, coming up with a plan to prevent the crisis from continuing is the answer here. Perhaps there should have been an opioid prescription tax in states just like liquor or tobacco products, where that money could go to addiction resources. Why they think those resources should come from this company and when they clearly don't properly collect taxes is beyond me. We are happy to make contributions out of kindness, care, and empathy to the issue, but this situation is so without merit it boggles my mind. I cannot think of something more immoral than coming back to shake the money tree and bankrupting thousands of retirees every so often when you need some more money because you did not adjust your local tax revenues properly. As our society stoop to such immorality. You all see that BlackRock, Goldman, or my firm, for instance, owns a stock, and you think that as big fat cats on Wall Street that can afford the stock plummeting to zero. But it is individual retirees that own it through those firms, people who are counting on that money for their future. On another note, I wish to discredit the 13D violations, though I feel no duty to, as those are something the SEC can take up with me if they want to question the very clear good guy in this situation, given this leadership's numerous betrayals and violations of both Irish law and our corporate governance rules. There was not one bit of harm done to the plaintiff itself as part of any of their 13D violation allegations. Nevertheless, alleged harm to the investing public is something that the SEC polices, not the individual companies themselves. This company was not harmed at all by my actions. They were threatened by my actions. They are clearly confusing those two words. As of this point where my firm had communicated with enough shareholders to surpass the 5% threshold of representation required by Section 1101 of the Companies Act of 2014 to call an extraordinary general meeting, we made the announcement via press release notifying that we had surpassed that threshold. At that point, we We then immediately were in contact with a law firm to file our 13D as required by Section 13D of the Exchange Act. However, due to high shareholder turnover in this stock, it turned out many shareholders on our list had then sold off the stock when we then had to garner a partially new constituency to meet the 5% threshold again to form an official group. In essence, we believed through data we had an unofficial group to be officialized, but when we reached out to those shareholders again requesting information to officially formalize that group under a 13D filing, they did not respond or had sold off their stock. So they were clearly not a part of that, even that unofficial group, if they could not even respond or did not own their shares anymore. We then did not solidify the group in that 13D filing until just before the 13D filing. If the plaintiff thinks they're able to effectively have a constant, precise count of hundreds of cattle as they herd them, not even taking into account that the shares held by each shareholder were ever changing by the day up until now, then they are more talented than I. But I did my best to abide by 13D regulations given the circumstances. The plaintiff claims that there are no exemptions for lack of response or administrative burden. It is indeed a burden to speak with hundreds of shareholders reaching out to me, an impossibility. So I chose not to carry through on communications with every shareholder that contacted me, so as to ensure they could not be deemed to be part of any construed overall group. And for anyone who did receive information from my emails to multiple shareholders, it is not possible to deem them a part of the group if they're not willing to give me the information to have them listed in a group filing. That is why we have also cut off all communications to the broader shareholder base beyond the official 13D group recently, and are only communicating with those individuals officially recognized as being part of the 13D group. Having mere knowledge of shareholders or having their emails does not mean an official group of shareholders under the regulations of 13D filings. I do not even know anything beyond many of their email addresses, in most cases not even a name. Again, if those shareholders do not respond to my request for data to be included in their 13D filing or no longer own their shares, they were very clearly not a part of the group. And my counsel who filed that 13D would tell you I was pushing them forward very impatiently to file that 13D as quick as possible, as I respect the United Securities laws immensely and also did not wish for any of the shareholders to sell off their holdings and potentially allow us to fall below the 5% 13D threshold yet again. Nevertheless, the nuances of my filing had no harm on this company, and if the SEC wishes to again question the clear good guy in this situation, then that is up to them and not this company. This company was not harmed as a company by any possible alleged nuance within the plaintiff's complaint regarding 13D allegations. Stakeholders were, however, immensely harmed by this board and management's numerous corporate governance violations and breaches of fiduciary duty than any of the allegations set forth against my firm. That is very obvious. And that harm will be ongoing until we utilize the democratic processes of a shareholder meeting to regain control of the company we own and the board that reports to us, who couldn't have further strayed from both their fiduciary duty to shareholders and creditors. As far as 14A violation allegations, that could not be more false that we are actively soliciting proxies. Where the plaintiff got that idea is beyond me and unfounded, very clearly. We had an initial proxy form that we initially proposed to possibly use, but it was discarded, as it is very obvious since we never turned over one alleged proxy form to the plaintiff. As of now, we do not intend to solicit any proxies, even if we were to call a shareholder meeting, as I believe it will be powerful for the shareholder base to speak their voice themselves. We as a group have the right under Irish law to sign onto a joint shareholder meeting requisition, but that is in no way a proxy. That gives no power to Buxton Helmsley over other shareholder interests and is a form that multiple shareholders are merely signing onto as part of the established 13D group to call a shareholder meeting under their rights afforded by Ireland. Also, all shareholders came to us. We did not have a shareholder list to work through to solicit shareholders or find them. We announced what we wished to do with regards to management reform. Shareholders reached out to us. Then some of them went so far as to join the 13D group that was recently established. Just as with the 13D violation allegations, the plaintiff itself was in no way harmed by any of their 14A violation allegations. They felt threatened, though, I am sure. And if they spent money trying to defuse a threat because they were so fearful of what they had done, I would say they misused misuse the money of this estate yet again, just as they did filing this lawsuit. And again, if the SEC wishes to question the good guy in regards to any possible violation, who did not have the resources of this company to employ an absolute army of lawyers at the expense of their shareholders and other stakeholders, as to possible 14A violations, that is their choice. But this company does not enforce or police the securities laws. They are out of their lane. The plaintiff also claims that the revived Mallinckrodt website was not under constant brute force hacking attempts. It indeed was taken down because of that. Luckily, my firm had it locked down like Fort Knox with security features to block IP address after so many unsuccessful attempts of trying to log into the administration panels. But I have countless hundreds of IP addresses that I'm happy to turn over that have been blocked for brute force hacking attempts just recently. Very interestingly, many of them came from Amazon data centers, which is not your typical hacker, likely a corporate hacker, and I therefore cannot rule out if any of those hacking attempts were possibly at the direction of the plaintiff in an attempt to forcefully diffuse the threat of this shareholder base organizing to overtake them. This allegation about the website was just so bottom of the barrel, illustrating how desperate the plaintiff is to poke holes in myself and Buxton Helmsley. Beginning to conclude, the plaintiff makes a prayer for relief in their complaint, but it is not a prayer for relief of harm. It is a prayer for relief of threat of such an aggrieved shareholder base and the power that they wield through the statutory rights afforded to them by the government of Ireland and its legislation. A threat of the very democratic processes that are in place to remove leadership of companies that do not heed to the wish of those at the highest point of the capital structure of the company, its shareholders, whom they do not lose a duty to as an ongoing part of this estate, even if they are under some false impression of insolvency. These directors had a duty to maximize distributions to all stakeholders in this capital structure and engage the path of maximum assurance those distributions would be maximized. And they engaged the exact opposite approach, capping shareholder distributions and even certain creditor distributions at zero off the bat. These prayers for relief are very logically based on the premise of a court, not in their country of incorporation, overriding and stripping the rights afforded to this shareholder base by that foreign country of incorporation, in this case, Ireland. If this shareholder base wishes to pursue the very numerous, very basic routes of maximizing and preserving the value of this company that this board and management didn't and had a duty to, then that is not a threat of harm, but a threat of justice being brought upon them for their betrayals and violations. Not my firm or anyone on that 13D filing is a threat of harm. Harm is sending securities to zero when they did not explore numerous ways to avoid such a travesty. And that is, again, a breach of fiduciary duty that very likely will leave these directors and officers personally liable for their actions under Irish law. These directors and this management that those directors obviously condone the behavior of by allowing them to remain in their positions could not have strayed further from the interest of its shareholders and creditors, for which they very clearly are fearful that our 13D group and those who may seek to join it could bring their day of reckoning. I wish to quickly go through each prayer of relief item. Relief request A would again require this United States court to strip the rights afforded to them by the Irish government. I respect your honor in this court more than I can say, but stripping the rights of an Irish company afforded to this shareholder base by the Irish government are rights that can only be restricted by an Irish court. It would also impede on the democratic rights of the shareholder base. And when we state that we wish to leave bondholders unimpaired and maximize value for the entire capital structure, unlike current leadership plans, hopefully leaving equity unimpaired while settling litigation with the interest of both shareholders and bondholders in mind, that is not an abuse of our democratic rights. It does not pose a harm to any stakeholders. It is the exact opposite of a harm and a very blessing compared to this management and board's current plans. The plaintiff knows that if they filed this complaint with the High Court of Ireland, they would be airing out all of their dirty laundry in terms of how they breached their fiduciary duty to both shareholders and creditors, along with violated our corporate governance rules numerous times over. That is the very reason they did not file this in the proper jurisdiction and are so confusing harm with threat. This management and this board knows that they would have immense worries if this information was brought before the High Court of Ireland, as they should. The settlements for pending litigation against Mallinckrodt can be settled many ways. Their way is not the only way, and it is clearly not the best way. They could have attempted numerous strategic alternatives for recapitalization in a way that did not impair stakeholders like they are attempting to with these restructuring plans, but they did not, and by choice and in violation of their fiduciary duties. When they say shareholders are engaging in a futile attempt to win a larger share for out of the equity money, again, they have no factual proof it would be out of the money in the numerous strategic alternatives to the current RSA that they did not explore. They act as though I am going to steal value for equity holders when if it is not there, it is not there. It cannot be created out of thin air. Though they say I pose a risk to the rehabilitation of Mallinckrodt when multiple stakeholders would agree that this is not equitable rehabilitation of the capital structure, but an utter destruction of the capital structure, and for no reason when so many routes of strategic alternative resolutions to our headwinds have not been explored. What this leadership is worried about is that I will explore all the ways they did not try to preserve equity and leave creditors unimpaired, including assets that they admitted to artificially suppressing on the balance sheet like drugs pending approval. If they had conducted a bidding process for those assets and equity like any other vested stakeholders, shareholders, and creditors included they would have realized many of their claims could not lack merit more. Mere frivolous claims against a company do not guarantee and factually prove insolvency. If you give in to such claims and allow them to sink you, then sure, you will be insolvent. But if you actually defend against the claims like a vested stakeholder with an interest in upholding your fiduciary duties to the fullest extent would, exploring every possible path of resolution and choosing the path that best assures the most positive outcome for all stakeholders, then you may achieve a completely different outcome, solvency and stakeholders being unimpaired either partially or completely. These very voluntary, continued, willful breaches of fiduciary duty will again almost surely bring on personal liability to our leadership, which is the exact reason we have already engaged in discussions with the Office of Director of Corporate Enforcement in Ireland, who is already investigating this board management and its actions. They have failed us miserably. Relief request B is also an issue with the lack of jurisdiction and would impede on Ireland's shareholder rights, as we are afforded the right to submit shareholder proposals and act through proxies as part of the rights afforded to this shareholder base through the Ireland's Companies Act of 2014 legislation. For instance, Section 183 of the Companies Act of 2014. Though we do not intend to, at present, again, solicit any proxies, as we wish for the shareholders to speak their own voice in the event of a shareholder meeting. And if we engage in any behavior that is in violation of Rule 14A or Irish statutes, that is again something the SEC would be in charge of enforcing, not Mallinckrodt. Of course, it is a given that Buxton Helmsley will not engage in any behavior that is believed to be in violation of Rule 14A or any other securities laws for that matter. I respect the securities laws immensely, and I do my best every day to abide by them. And if my firm missteps, it is not by choice, but by accident. And if we misstep by accident, that is between the SEC and my firm to speak about. The plaintiff is not the police of the securities laws. Shareholder meeting requisitions are also in no way a proxy. That is merely a joint request, exercising our rights under Irish statutes to call a meeting, shareholder meeting amongst one or more shareholders, which itself does not give Buxton Helmsley any power over any of the other requisitionist interests. If many shareholders sign one form together requesting an extraordinary general meeting, that again in no way gives Buxton Helmsley any power over those other shareholders' interests. To date, not one bit of harm has been done to this company as a result of any Rule 14A violations alleged by this company. Not one alleged form, any of the exhibits within the 3 worth of pages that was served upon my office and myself as part of this case has been submitted to the plaintiff to date. Not $1 is spent by the plaintiff to defend any proxy materials allegedly garnered and submitted in violation of Rule 14A. But many dollars of this estate have been spent and wasted here as part of this lawsuit because this board and management feels utmost threatened. They continue to squander our money and other stakeholders' money because they are not impacted by it. They have no vested interest in equity value anyhow, so why should they? They squandered the money that could have gone to creditors with resources dedicated to this lawsuit too. Those they again claim to have such an astute duty to, trying to oppress a shareholder base. An absolute waste of resources. Relief request C, just like relief request A, would require stripping rights afforded to the shareholder base by a foreign country in a U.S. court. The shareholder base is, again, far from a threat of destruction, as the complaint alleges, given we wish to maximize value much further up the capital structure through our strategic alternative resolutions, where this leadership wishes to cap distributions to multiple stakeholders from the get-go at zero. The plaintiff also alleges that liquidation would be considered destruction and harm, which illustrates how they have not put their creditors and shareholders first, as they are required by Irish law, but instead themselves as employees. It is all over the internet that under Irish law, your duty to your employees is vindicated upon insolvency and shifts solely to those in your capital structure, your creditors and shareholders. That does not mean that I do not care about our employees, as I greatly do, and this company is worth so much more as a continuing enterprise where I would never wish to see it liquidated. But it is this leadership's legal duty as directors and officers to heed to Irish law surrounding their statutory duties and not stray to self-serving interests as insiders of this company. While I do not wish to see this company liquidated, though, we are at this table with an obligation as part of Irish law to resolve these issues with the creditors' and shareholders' interest in mind. It is the duty of any director at this moment and any director elected in the future, and we cannot stray from those statutory duties like has already happened here. Relief request D, just like relief request A and C, would require stripping us of our rights afforded to the shareholder base by a foreign country in a U.S. court. Relief request E would require stripping us of our rights afforded to the shareholder base by a foreign country in a U.S. court. Relief request F is absolutely flabbergasting, as this shareholder base is actually interested in exploring all of the routes to maximizing estate value that this board and management neglected. If this shareholder base wishes to explore all those numerous routes to hopefully leave all stakeholders unimpaired, then that is far from a threat to this estate. What it is a threat to this leadership's positions and this master plan for them walking out with a lighter balance sheet and fat MIP for insiders. Again, it does not matter whether they are the same insiders or not. It is value being improperly directed to employees of this company in stark violation of their fiduciary duties to shareholders and creditors at this stage of declared insolvency, plain and simple. As for them feeling threatened, I am sorry, but I did not think I would be put in this position of having to call a shareholder meeting because they chose not to uphold their fiduciary duties to shareholders and creditors and could not follow Irish law. I trusted them, but I very apparently should have not. The threat of harm that must be enjoined in this management is this management and board, given their demonstrated inability to follow their fiduciary duties. Relief request G, there were no damages to this company, but there have been immense damages to the shareholder base and other creditors as a result of this management and board's actions. All stakeholders would fare better without all this time being spent contemplating impairing stakeholders when numerous other routes have not been explored, possibly concluding that such impairments are not even necessary. When I receive calls from international shareholders with very powerful connections, telling me that they offered this management undefined financing opportunities to recapitalize without possibly having to impair stakeholders, and this management did not even respond to those open-ended offers of a lending hand, that makes my blood boil. If anything, stakeholders should be owed damages for the voluntary destruction of value of this board and management. Choosing not to explore numerous routes of value preservation maximization is neglect and a choice. Any Irish court would agree that it did not just slip the mind of this management and these directors to, as a very last resort, hold a meaningful bidding process of the company and its assets to assess the path of maximum value distribution to all stakeholders in the capital structure. But they couldn't now, as these books are literally cooked. If what they said about assets like our drug pipeline being worthless is how those assets are accounted for on the books. Even with that said, that should have been a last resort after actually attempting to settle this litigation with a strategy that truly takes into account those whom our directors have a fiduciary duty to, shareholders and creditors, those in their complete capital structure, no interest as to their personal gain, plain and simple. Relief request H, I surely hope this company will not be rewarded for bringing forth this malicious, meritless, and frivolous litigation to oppress a shareholder base, attempting to do so in the United States, the wrong jurisdiction, because they are worried about a lot of the information being brought to light in their country of incorporation, which would discipline them severely if they brought forth these prayers for relief there. This litigation was brought forth to muzzle my firm and many others even more forcibly than they have attempted so far. First, the company we own does not respond to our letters. Then they sue us for sending them. They've illustrated their character immensely with this lawsuit. They spent endless thousands allowing their army of lawyers to draft countless pages of legally meritless requests, serving at minimum at least 6 reams worth of paper on me so far, more by the day, sent expensively with overnight shipping, and they want me to now pay for it. I could not be more appalled. What a waste of the money of this estate and what a waste of the time of this court. Your Honor, I respectfully request you dismiss this suit on grounds that these prayers for relief are for relief of threat of justice through the democratic process of this shareholder base is contemplating, far from a threat of harm, given our wish to engage the numerous routes of enterprise value preservation and maximization that this board and management chose not to and are refusing to engage, that the company filed this complaint in the wrong court of jurisdiction, almost surely on purpose, and that this complaint is nothing more than an attempt of malicious litigation to further oppress and stifle the shareholder base. Thank you for your time.
Thank you, Mr. Parker. Mr. Bertog, any rebuttal?
Yes, briefly, Your Honor. Needless to say, the debtors could not disagree more strongly with the unbroken stream of mischaracterizations and falsehoods that constituted what was purported to be an argument set forth by Mr. Parker. Frankly, Your Honor, Mr. Parker's outrageous disquisition proves why a TRO is needed. And just to recenter the proceeding, we are here on the debtor's motion for a temporary restraining order. We've set forth the legal standard, and I'll walk back through it briefly to demonstrate how Mr. Parker has just proven our case. First, we need to demonstrate likelihood of success on the merits. There are 3 separate claims asserted. The first is for violation of proxy procedures and laws under Rule 14A3. Mr. Parker has undoubtedly solicited proxies both through his sending of requisition forms and a document entitled Proxy that he requested shareholders return. The fact that Mr. Parker may now seek to disavow reliance upon those misguided solicitations does not make their issuance any less a violation. He's just admitted that they occurred. Second, Rule 14A9 prohibits materially misleading statements. The last 45 minutes of this proceeding were an unbroken stream of deepening, unsubstantiated misstatements. Mr. Parker presented no evidence. As the court said, the factual assertions should be disregarded, but separate and apart from their impact on this proceeding as a fact in the record, they are a demonstration of his willingness, his determination to use any public forum to deepen his ad hominem attacks on management, his accusations leveled at the company, and his misstatements about the status of this reorganization and the insolvency of the debtors. So he's also proven the 14A9 violation. Third, the 105 injunction claim, Mr. Parker has confirmed that he will seek an extraordinary general meeting, and that if he cannot recover for equity, he will seek liquidation. That is the exact reason we brought the 105 claim. So he's proven that as well. And just as an aside to correct what I hope will help Mr. Parker not make another misstep, the section of the Companies Act on which he relies, Section 1101, does not apply to Mallinckrodt because it applies to issuers of securities listed on EU-regulated exchanges, which Mallinckrodt is not. It's just irrelevant. So I hope we don't hear any more about it. However, Mr. Parker's reliance or purported reliance on that section just demonstrates he believes he has the authority now to issue a requisition, which is why we're here on a TRO application. Second, on irreparable harm, that disquisition was a demonstration of irreparable harm. It was irreparable harm in itself because it's unsubstantiated false and deepening false statements, and it was a promise to seek to do more and to carry out the requisition. Mr. Parker did not address balancing of the equities, and he did not address the public interest, so we'll assume those two pieces are conceded. So in summary, on the TRO application, Mr. Parker just proved the case. Only one other point to make, Your Honor, which is Mr. Parker's suggestion that this court lacks authority or somehow contravenes Irish law if it enters a TRO or an injunction against him. Your Honor, nothing could be further from the truth. We have requested an injunction of a U.S. person, Mr. Parker, and a U.S. entity, the Buxton-Helmsley Group, to prevent them from continuing violations of U.S. law and continuing disruption and damage to a U.S. restructuring of which Mallinckrodt PLC is the top company. There is no issue of Irish law implicated. There are no comedy concerns. It's not even an extraterritorial application. Even if it were, it is beyond cavil that this court has authority to use its in personam jurisdiction over these defendants to enjoin the actions to destroy the bankruptcy estate anywhere in the world. So there is no issue of this court's authority. The court has ample authority to issue the TRO and a preliminary injunction, and Mr. Parker has spent the last 45 minutes demonstrating why the court should. And that's all I have, Your Honor.
All right. Thank you, Mr. Murtaugh. Mr. Eggerman, raise your hand.
Good afternoon, Your Honor. Can you hear me okay?
I can.
This is Daniel Eggerman with Kramer, Levin, Naftalis, and Frankel on behalf of the Governmental Ad Hoc Committee. Mr. Parker has made some rather inflammatory remarks regarding the opioid crisis, as well as the companies, the governmental entities, and the victims' respective roles in that crisis. To blame the victims for that crisis is simply irresponsible. We obviously dispute his uninformed characterizations in that regard, but recognize that this is not the time or the place to engage on those issues. I just did not want our participation in this hearing and any silence on our part to be construed as any form of endorsement of those reckless remarks.
Thank you, Mr. Eggerman. You sure? Raise your hand. I'm not going to allow everybody to speak here. I mean, this is a adversary proceeding with one plaintiff, so the debtors, the defendants are Mr. Parker and his company. So, and there's no need to reserve any rights on the record. There's no need for any of that. But Ms. Schuer, do you have something in particular that you want to add?
Good afternoon, Your Honor. May it please the court, Therese Schroyer for the Securities and Exchange Commission. Your Honor, thank you for that about the reservation of rights. That is what I had intended to do, just with respect to any findings that the debtors are seeking under the federal securities laws. Also, just with respect to the quote shared by Mr. Murtaugh previously, which implied that the SEC had endorsed certain conduct. To my knowledge, the SEC has not previously taken a position on the conduct at issue in this adversary proceeding. Thank you, Your Honor.
Thank you. Mr. Feinstein, I don't see you. Feinstein, are you there? All right.
Your Honor.
Who's speaking?
This is Alexander Parker.
Yes, Mr. Parker.
Yes, I would just like to say and affirm that my firm and also my legal counsel who prepared the 13D filings had conversation with the SEC over the 14A violation allegations. So I would just like to say that. That's a
factual question, Mr. Parker. And as I stated, if you're not under oath and testifying, I cannot accept it as evidence in this case.
I understand.
And it would be hearsay in any event.
Okay.
Mr. Feinstein. You're muted. I can't see you either. Your video's off and you're muted. All right. All right. Mr. Parker, while I appreciate your impassioned argument, I disagree with you that I do not have jurisdiction to enter an injunction in this case. These debtors are before me. You are a U.S. citizen residing in the United States. Your company is also, and therefore I have jurisdiction to enter injunctions to, one, protect this debtor, and I have the authority to do so against any party for taking actions anywhere in the world that might harm this debtor. As Mr. Murtaugh said at the beginning, standard for granting TRO is the same as that for granting a preliminary injunction. One, the movement has to show a likelihood of success on the merits. Two, they have to show irreparable harm if the relief is not granted to the moving party. And three, balance that harm against any potential harm to other parties if the relief is granted. And four, the public interests involved in the case. And that is Johnson & Johnson Orthopedics, Inc. versus Minnesota Mining and Manufacturing Company, 715 F sub 110, District of Delaware, 1989. And Takeda Pharmaceuticals USA, Inc. versus West Ward Pharmaceuticals Corporation, 214 Westlaw 508860, District of Delaware, 2014. Based on the record presented by the debtors, including the declarations of Mr. Eisenberg, Mr. Viola, and Mr. Ranello, including the exhibits attached to those declarations, I find that the debtors have met their burden of establishing the grounds for a temporary restraining order in this case. First, the debtors have shown a likelihood of success at trial of showing that the defendants have violated the Securities and Exchange Act regarding the solicitation of proxies for the purposes of calling a shareholder meeting to replace the current board of directors for the express purpose of attempting to call a halt to these Chapter 11 proceedings, constituting a clear abuse that threatens the debtors' ability to reorganize. See in Ray SS. Body Armor 1, Inc., 527 BR 597, Bankruptcy, District of Delaware, 2015, and the authorities cited therein. Second, I have no doubt, based on the record in these cases, that the debtor would suffer immediate and irreparable harm if the defendant's actions are not prevented. I already denied a motion to appoint an equity committee in these cases because, among other things, the debtors are hopelessly insolvent. Replacing the board with parties who oppose the debtors' reorganization efforts would destroy the possibility of a consensual reorganization of a complex and case that involves complex and extensive liability issues. I cannot imagine anything that would jeopardize debtors' reorganization efforts more than completely shifting direction midstream without any showing of a necessity to do so. Third, there's no harm to the defendants in preventing their improper and misleading proxy efforts at this time. As Mr. Murtaugh pointed out, the injunction in this case will only last for a short period of time until we can have a full hearing on a preliminary injunction, and therefore, in that short time, there's no potential harm to the defendants. Finally, the public policy is clearly supports the relief requested here. The public has an interest in ensuring the efficient and expeditious rehabilitation of debtors generally, and particularly so given the serious public interest issues involved in this case. Therefore, I will grant the temporary restraining order. I did receive, Mr. Murtaugh, a black line and updated order this morning. That is fine, although we do need to add into it that I'm going to set a hearing for the preliminary injunction. While there's a question of whether the 14-day requirement applies, given that this was a TRO on notice, but also given that Mr. Parker does not have counsel yet, I'm going to treat this as if it was one that was not given on notice, so I'm going to apply the 14-day requirement. The 14 days would put us to April 2nd, which is Good Friday. I think that's also a court holiday. So we're going to have the preliminary injunction hearing on Monday, April 5th, beginning at 10 a.m. Mr. Parker, you can agree with the debtors to extend that period of time. I would strenuously suggest that you retain counsel immediately, because you're going to need them to guide you through this. And Buxton Helmley is going to need one, or they're going to be defaulted because they can't appear pro se. So you need to get a lawyer and get one quickly. And as I said, if you can agree with the debtors to extend that period so that we can move that preliminary injunction hearing from April 5th, because preliminary injunction hearings are obviously much more lengthy, much more involved than a TRO. It requires the introduction of evidence. And so I would suggest that if you obtain counsel, you might want to talk to them about moving that date. I'm sure they're going to want more time anyway. Of course, the TRO would remain in place until I have a hearing on a preliminary injunction. You understand that? Okay, you're muted, Mr. Parker.
Yes, sorry about that.
All right, any questions, Mr. Murtaugh?
Just one, Your Honor. Given that the volume of the presentation by Mr. Parker that constituted factual allegation, I know we had discussed before Mr. Parker spoke that none of that would be treated as evidence in the record, and I understand that there is essentially no way to have it removed from the transcript of these proceedings, but I just request, to the extent that any of those fact assertions are or could be considered part of the record in these proceedings, that they be stricken.
Yes, they are. Any factual assertions in Mr. Parker's presentation are stricken because he was not under oath, he was not presenting evidence, and they're not a part of the record in this case.
Thank you, Your Honor. Understood.
And if you actually want to include something in the form of order to that effect, that's fine.
I'll confer with my colleagues, and we may consider an updated form of order.
All right. And you are going to have to update it anyway because you have to put the date for the preliminary injunction hearing in here. So, and you can submit that under COC.
Understood. Thank you, Your Honor.
All right. Anything else for today?
Not from PLC or the other debtors, Your Honor.
All right. All right. Thank you. We are adjourned.
Thank you.
Thank you, Your Honor.